As I said, good afternoon. Welcome to this first webinar. It's the first webinar of a three-part series on legal, ethical and governance challenges in exposome research. And the webinar draws on experiences from the Human Exposome Assessment Platform project and also the Ethics and Law Working Group of the European Human Exposome Network. So the webinar aims to offer practical guidance to exposome researchers on managing sensitive data in compliance with evolving legal and ethical standards. Firstly, I will introduce the HEAP project and the exposome, which I think probably everyone will be familiar with this, but just to recap, the exposome describes all of the environmental exposures a person encounters throughout their life, including physical factors, for example, air, water and chemicals, but also socioeconomic and psychological factors as well. And HEAP, the HEAP project, it stands for the Human Exposome Assessment Platform. And it's a 5-year project that finishes at the end of June this year. It's funded by the EU's Horizon 2020 research programme. It focuses on exposome data analysis using several pilot research projects, and HEAP uses new types of data that haven't previously been used in scientific research, including data from consumer receipts and from wearable sensors. Exposomics is a new scientific field. It involves studying large amounts of data from a wide range of sources. And this includes transferring data across borders and keeping sensitive data and analysing sensitive data in a secure environment, among other challenges. Our presenter today is Daniel Groos. He's a legal researcher at the HEAP Consortia partner Lygature for their health, law, privacy and ethics portfolio. Daniel is the coordinator of the EHEN Ethics and Law Working Group, and his research is focused on privacy and data protection in large-scale research consortia. And he's worked with scientific researchers from the HEAP pilot projects on appropriate models for data governance and data management. Now, Daniel's talk will cover lessons from specific legal tasks that were undertaken in the HEAP project, including strategies for the safe transfer of data to third countries, basically using the HEAP pilot projects as an example. Daniel's talk will be in 3 parts, and there'll be a pause after each part for Q&A. So you may use the Q&A function to ask any questions, and we'll stop after each section to address those questions. There'll also be the chance to pose questions for about 10-15 minutes at the end, and the talk should last, this session should last an hour until 3 o'clock European time. So just to recap, just to give you an overview of what Daniel will be covering today, he'll be covering issues in international collaborative health research and the legal complexities that can arise in relation to this, and some approaches of how this can be addressed. The second part will focus on exposome research in the context of the right to health, so taking a public health lens as opposed to the more traditional individual rights over personal data lens that we've been used to. And the third part of his talk will focus on the European Health Data Space, or EHDS. The EHDS promises to foster the reuse of health data on a grand scale. Daniel will discuss the concept of consent as a legal basis for processing health data in the light of the new regulations linked to the European Health Data Space. Okay, and with that, Daniel, I will hand over to you. Thank you.
Yes, thank you, Heather, for the introduction. So yeah, as Heather just explained, the agenda for today is divided into 3 parts. First, I will talk about the ethical and legal tasks that we had in work package 2 in HEAP. Then I will talk about exposome research in the context of the right to health. And then finally, I will talk about what the future holds for exposome research. But let's start with some of the ethical and legal tasks that work package 2 had within HEAP. First, I do want to add that I did not do this on my own. I also did this together with my former colleagues, Martin Boekhout, and especially Ever Ben van Veen. He was also very much a part of this. And currently, I am, together with my colleague Rita Azevedo, who also works at Lygature, finalizing the legal tasks of work package 2. But so the tasks that we had were, first of all, a data protection impact assessment, the DTIA. That led to a data transfer impact assessment. And then we also did a mapping of all of the ethical and legal challenges of exposome research. And finally, we also worked on a framework for the data governance, about which a future webinar will go into that in more detail. But so starting with the data protection impact assessment, basically this was a way to assess which possible threats to data protection and privacy should be considered, and also to provide a roadmap for how to address these possible threats further. So in the description of the envisioned data flow, first of all, we looked at all of the data sources of the HEAP project, and we also gave a description of the HEAP platform. Now, this DTIA led to a number of preliminary conclusions. First of all, there was the need to further specify the distribution of responsibilities. There was also a clear need for access and use procedures. Now, these two things, they were further clarified in the governance framework. But then there was also a third conclusion, namely that there was a need to further investigate data sharing beyond the European Economic Area. So yeah, when it comes to data sharing beyond Europe, clearly cross-border but also cross-continent data sharing is a regular and also a crucial feature of data-driven collaborative health research, and also trends towards stimulating fair data stewardship and data reuse only further this. Now, the GDPR, the General Data Protection Regulation, does allow for data sharing with parties based in third countries outside of the European Union, but only under very specific conditions. Now, for those of you who are not that familiar with the GDPR only applies in certain territories, namely the European Economic Area, but it also applies to transfers of data to outside parties. Now, and this is important because there was the HEAP pilot study. And in the HEAP pilot study, there were 100 pregnant women in Finland. And what they were trying to do in the pilot study was to measure the exposure to airborne particles and toxic substances to analyze the effect of this on the health of mothers and their babies. And this was done through the use of two types of devices. Now, device number one was a health data logger, which recorded personal health and location data. And this was processed at a platform in Finland. So far, there were no particular issues with data transfer in that instance. But then there was also device number two, which was an exposome meter, which collected environmental exposure data via filter cartridges. And these filter cartridges had to be sent to the United States for analysis due to the need for specialized reference data, which at that moment was only available in the US. Now, clearly, this was a transfer of data to the US, and therefore there was also a clear need to assess the risks of this. And this was done through what we call a data transfer impact assessment. Now, when it comes to transferring data to a third country, there's always a legal basis needed for doing so. Now, that could, for instance, be done on the basis of an explicit consent. But explicit consent as a way to share data outside of the EU can only be done for, let's say, short amounts of data transfers. And though in this case, it wasn't really a possibility. Now, it could also, for instance, be that there's an adequacy decision, meaning that the European Commission has decided that the third country to which the data is being transferred has an equal level of protection to the European Union. That also wasn't the case here. So it was decided to use a standard contractual clause as a legal basis for the transfer. This is basically a contractual arrangement with the analyzing party that is located in the US. However, there is still a need to assess the impact of the transfer on the rights of the participants. And this is done through the DTIA, which is about assessing the possibilities and the conditions under which the data sharing may be possible in the context of a transnational collaborative health research. Now, when it came to the risk assessment, basically the main concern was the access to the data by the US public authorities for surveillance purposes. Now, there are a number of US laws, such as FISA and the US Cloud Act, and we will not go into detail on those laws today. But basically, these laws run counter to certain essential guarantees. of European law. So in European law, basically any kind of interference in privacy through a surveillance program should not go beyond what is deemed necessary and proportionate in a democratic society. And through this European perspective, basically the US laws didn't meet these standards. However, this risk of surveillance can be addressed through certain measures that make access to the transferred data either impossible or ineffective. So basically, the aim was to transfer the pseudonymized data in such a way that it could basically be considered anonymous for the recipient, but also any other party, such as an intelligence agency that wants access to the data. Now, how do you achieve this? Now, in this specific case, the cartridges were transferred along with a pseudonymous identifier, which remained under the sole control of the data controller who was in charge of the HEAP pilot study. And also, the data generated from the cartridges could not be linked back to individuals without doing similarly detailed measurements of the additional data. But this additional data was under the control of the data controller, and the receiving party in the US had no access to this additional data. So basically, in our estimates, the risk of seizure of these data by US authorities was, in our opinion, very minimal. Because for the first reason that the data could not reasonably be linked back to any personal data. And also, we couldn't really think of any reason that surveillance authorities would be interested in these particular data sets. When we looked at a lot of real life examples of when intelligence agencies basically wanted to get hold of health data, but no real world scenario we could come up with that in this instance US authorities will be interested in these data sets. And also another thing is that the data generated from the cartridges was by itself not legally considered to be health data. It was only indicative of personal health status in combination with other data, and it is this other data precisely to which the recipient in the US had no access. So as part of the DTIA, we also proposed a number of supplementary measures. The first is to only include data and pseudonyms through which the transferred data remains de-identified. So identification of the data subjects should only be possible through having access to additional information, and also the link between the pseudonyms and other information through which the exposure measurements data can be used to identify data subjects should remain exclusively at the data controller who was in charge of the pilot study. Then it's also important to protect the additional information from risks of disclosure and unauthorized use, so that the re-identification can only be done by the data controller. And lastly, to make sure that the data and the pseudonym are not attributable to data subjects, even when, for instance, cross-referenced with information which the US public authorities may possess, such as communication data or either publicly available data. So that is it for the first part of the webinar. Are there any questions so far?
There are any questions at this stage, you may put them in the Q&A and we'll pick them up. While we're waiting for anyone to ask some questions, I wanted to ask Daniel, regarding the measures that make access to transferred data impossible or ineffective. You mentioned transferring the data so it could be considered anonymous for the recipient. Can you go into more detail on that?
Yeah, so when it comes to data anonymity, there are basically two competing views. There is the absolute view on the anonymity of data, and then there's also the relative view of the anonymity of data. So when it comes to the absolute view of data anonymity, basically the nature of the data itself is decisive in considering whether the data can be considered anonymous or not. When it comes to the relative view, however, it depends on who has access to the data under which circumstances. So, I mean, this has been subject of like a legal debate on these two competing views. However, if you look at recent discourse, but also recent court cases of the European Court of Justice, basically it is clear that the relative view on anonymity is clearly the legally sound way of looking at this. So in this instance, basically, the recipient in the US only received data that was pseudonymized. So obviously, these data sets would be considered personal data to the original data holder. But however, the party in the US had no means of access to additional data through which they could identify the persons that were in these data. So I hope that kind of like clears it up, this distinction between the absolute view and the relative view and anonymity.
Yeah, thank you. Thanks very much. If there are no further questions for the Q&A at this stage, maybe we could carry on, Daniel, and then we could take some more questions at the end.
Exactly, yes.
Yeah.
Great.
Okay, thanks.
So that brings us to the second part of the webinar, which is exposome research in the context of the right to health. So as part of the tasks that we had in work package 2, one of them was a deliverable on the ethical challenges of exposome research. Now, originally, we were trying to provide an overview of all of the existing literature on this topic, but during the drafting of this, basically the focus shifted towards examining exposome research in the context of the right to health. And that was because basically exposome research is actually a conjunction of various LC discussions. Now, LC means ethical, legal, and societal implications. And these discussions are data protection and big data research, public health, and the role of governments in advancing this, but also to what degree citizens are responsible for their own health. Now, we found that the typical LC discussions tend to be very much focused on ensuring that the research methods respect the rights of participants. And usually this is centered on finding a balance between the individual autonomy of the participants and the collective benefits of research. But this view to us seemed too narrow. So the purpose of research itself is also often lost in these discussions. And therefore, with this deliverable, we try to broaden the discussion by exploring exposome research within the context of its potential to also contribute to a just society. Now, that of course begs the question, well, what do we mean with a just society? Before I get into that, I first want to look at a definition of public health, and that is as follows. The science and art of preventing disease, prolonging life, and promoting health through organized efforts and informed choices of society, organizations, public and private, communities, and individuals. Now, if we look at this description of public health, we can see clearly that it is not the same as medicine or healthcare, which is aimed at individuals, but instead public health is aimed at groups of the population and is very much focused on interaction between people and their environment, which brings us to the right to health, which is comprised of two aspects. The first is the right to health care, and the second is the right to health protection. Now, to make this a bit more clear, you see here the following graph. Now, in the middle, we see a green circle, which is the right to data protection. And from our findings, most of these LC discussions that are published are very much focused on the green circle, so the right to data protection, and then the blue circle is the right to health protection, which is public health. And then the red circle, which encompasses everything, is the right to health. And we really wanted to have this all-encompassing view, basically, which is why we decided to center it on the right to health. Now, getting back to what we mean by a just society, obviously there are various conceptions of what this means, and we don't have the time to get into that today. However, for exposome research, we cannot completely ignore the justice issue, because if exposome research is indeed concerned with the right to health, and the right to health is also part of the conception of a just society, we thought, well, shouldn't questions of justice not also extend to what research should aim for and which research to prioritize? So basically what we did in the deliverable was contain a sort of a proposal in which we wanted to challenge researchers to define, first of all, what type of research should be prioritized, and second of all, well, what should research aim for? Now, the first question, what type of research should be prioritized? You could, for instance, think of, well, should exposome research prioritize less advantaged groups? Or, on the other hand, should it prioritize what most citizens will profit from? And already in these two options, you see two very different conceptions of how research can contribute to a just society. Now, the second question, what should research aim for? This is basically, the the end results of research. What kind of measures should these inform? So what kind of public health measures should be pursued? Should they be, first of all, be about informing the general public, or should it go a step further? For instance, paternalistic measures that directly intervene in our personal autonomy. And also here you see a very different view, whereas the first, only informing the general public, is more in line with a classically liberal view of justice, whereas the second part, sees a much greater role for governments in pursuing public health. However, these decisions on research priorities are, in a democratic society at least, not made by the researchers themselves. They are made through the democratic process. However, researchers do have the ability to interact with their research participants on what turns the research should take. And that could happen through what we call participant-facing governance, which is a form of governance that fosters trust, enhance participant engagement, and also, benefits society at large, ultimately. Now, of course, that sounds nice, but how do we achieve this? And it can be achieved through what we call consent for governance, which is a different way of framing consent. Because typically, when it comes to consent for processing personal data, the consent has to be very specific. It has to be so specific that when it comes to research, this is often quite hard to, at the start, or when you're collecting data, to fully describe what you are going to do with the data exactly. However, consent for governance places an emphasis on the ongoing governance obligations to protect the interests of participants, which makes it different from the typical way of consent, where the emphasis is placed on the exact nature of data processing and which exact parties will have access to the data. And also, we think that the latest developments in Europe, namely EHDS, may also create more room for broader forms of consent. But I will get back to that in the third part of the webinar. But before we go there, are there any questions so far?
I could just ask a quick question, Daniel. So you propose consent for governance as a way to place exposome research in the context of the right to health. Doesn't that apply also not just to exposome research, but in general to health research, or what's specific to exposome research in this?
Well, definitely, this whole part about exposome research and the right to health, it also, applies to health research more generally. But why this is especially important for exposome research is because, well, some people describe exposome research as being essentially hypothesis generating instead of hypothesis driven. And with hypothesis driven research, generally you have a very clear research question. And it is also quite clear for which exact goals you want to process the personal health data. But when it comes to hypothesis generating research, basically what you're looking is you collect a lot of data, and in analyzing this data, you can come up with all kinds of different research questions. And I think that's kind of like the nature of exposome research itself, and also what makes it different from just health research in general. But when it comes to these very specific views on consent, where you have to be very specific in what you're going to be using the data for, basically it's kind of hard to really properly merge that with exposome research, which is why I think this is especially pertinent for exposome research.
Right. So exposome research is focused more on generating research questions than actually answering them. Kind of comes potentially a little bit later in some cases.
Exactly. Yeah.
Okay.
I do want to mention though that Kaspar Saferlu has actually written a nice paper on this, and I think recently his dissertation also went into this particular topic.
Okay. Thank you, Daniel. So if there's no other questions at this stage, we could.
You're muted at this moment.
Yes, sorry, I unmuted myself too quickly. We can move on to the next the next part. Thank you. Cheers.
So that brings us to the final part of today's webinar, which is looking at what the future holds for exposome research. So let's start with the European health data space. Now, I think many of you may already be familiar with the EHDS, but I'll just give a very quick refresher on what this is exactly. So the EHDS is a legal framework for a European health data ecosystem. And the goal of the EHDS is basically twofold. First of all, it's about strengthening the information position of European citizens through giving them more control over their health data. And secondly, which is important for us, it's also about fostering the reuse of health data, which is what is called secondary use in the EHDS. Now, basically, the EHDS contains two sets of rules. First of all, there are the rules for the primary use of health data in the context of healthcare delivery. So basically, this is any use of electronic health data for the purposes for which it was originally collected, being healthcare. But then it also contains a second set of rules for the secondary use of health data. This is the use of data for purposes other than those for which data was originally collected. And this also includes scientific research. Now, the regulation creates a right of access to health data for health data users and an obligation for health data holders to make data available for secondary purposes. Now, the EHDS does provide a number of opportunities for research and also for exposome research, more generally speaking. So first of all, the categories of health data that are under scope for secondary use, these are very broad. They include, among others, data from electronic health records, data from public health registries, data from research cohorts, and also data from biobanks and much more. These are only just a few examples. So this does provide an opportunity to make cross-border data requests through a central service. So basically, researchers can request access to health data through the Health Data Access Body, the HDAP. So in the near future, every member state in Europe will have, or maybe have multiple health data access bodies through which these requests can be made. Now, at present, basically cross-country research requires navigating a rather complex set of agreements on data use, on the transfer and storage under the various national legislations. And the EHDS will, first of all, it is intended to reduce these bureaucratic hurdles by more closely aligning the national laws on the secondary use of health data. However, when it comes to the processing of health data, this must take place in SPEs, and these are secure processing environments. So the SPE will be part of the Health Data Access Body, and it is only within such an SPE that a data user can perform analyses on the health data. And the idea is that within an SPE, you can only download the aggregated data itself. So it's supposed to be a very safe way of performing analyses on the data. However, there are some common issues with SPEs, such as having a limited computing power, there's a lack of AI analytics capabilities. There may also be a rather slow approval process for integration of specialized research tools. However, there is the expectation that these environments will, evolve and become better over time. These are just some of the experiences of FinData, which is basically a precursor of the EHDS. But most importantly, and I think the most significant opportunity the EHDS has for us is that it is based on an opt-out system. So currently, when it comes to the secondary processing of health data for research, well, obviously you always have to have a legal basis for the processing of personal data under the GDPR. Now that can be either consent, but the GDPR also provides certain exemptions to consent. However, there's a lot of legal uncertainty in many member states on when such an exemption to consent exactly applies, especially in the Netherlands, where I'm from. This is a common problem. And besides that, as I already mentioned in the part before this, is that consent under the GDPR has to be very specific, which creates all kinds of problems when it comes to research. However, the processing of health data for research within the context of the EHDS will happen based on an opt-out mechanism. And that means basically that consent is presumed to be given unless someone makes use of their right to opt out, in which case their data will no longer be used for secondary purposes. And we do think that this provides a clear opportunity to reassess and possibly also broaden the current definition of consent. Now, I think already in the Netherlands, you do see that this is being taken into account in new legislations. And this may also, play a role in the legislations of other member states. And also, I think the opportunity here is that this year, if I'm not mistaken, there will be a new guideline of the European Data Protection Board on scientific research, and they have also promised to, give more information on consent and how broad consent can be. Now, so also we may want to, when the draft of this guideline has been published, reply to this if we're not really in agreement on this. And then the second part, which is also just coming back to what I talked about at the start of this webinar, which is data transfers outside of the European Union. Because since we performed the data transfer impact assessment for HEAP, there have been some things happening. First of which is the EU-US Data Privacy Framework, the DPF. This is basically a mechanism for personal data transfers to the United States, which makes it consistent with European law. And this was in part facilitated by an executive order of the Biden administration. And this executive order also contained a redress mechanism for complaints lodged by data subjects in the EU on alleged unlawful access by US intelligence agencies. Now, this DPF only applies to organizations or businesses that are certified under the DPF, but because of the aforementioned Executive Order 14086, it does make the DTIA for transfers to the US considerably easier. However, as there has been a new US administration, many of the executive orders of the Biden administration have been revoked. So there were some worries that Executive Order 14086 would also be revoked. However, that has not yet happened. But still, the future of the DPF does remain unclear. So this is something to take into account when you are transferring data from Europe to the US. Are there any questions on the third part of the webinar?
Thanks, Daniel. I have just one question. Would you be able to tell us a little bit more about the pros and the cons of each system when we're talking about opt-in, which is asking participants for active consent, versus an opt-out, where when an opt-out, I think consent is presumed to be given unless you make use of your right. Is that right? So could you just give us a quick overview of the pros and cons?
Yeah, exactly. So, when you're looking at it from a research perspective, basically when you compare the opt-in system to the opt-out system, one of the first things you notice is that when it comes to opt-in, there are many people who simply do not reply to requests for consent for using their data. So, when you're looking for participants to take part in the study, or you're looking to achieve consent for using the data, you just simply have a lot of people that do not respond to these requests. So that's the first problem. But also the second problem is that there is a certain kind of bias in the results, because when you use a consent system, which is the opt-in system, what you see is that the people that give consent, that do respond to these requests, tend to be there tends to be an overrepresentation of males, and you also see that these tend to be people that are from the more higher socioeconomic background, and you simply have less people that ultimately take part in the study. And when it comes to opt-out, you do not have these issues there. You don't have the issue of the non-responders, and there's also no bias in the results themselves. However, some people do think that opt-out basically it gives people less control over their data. So for some people, that is an issue from a purely a privacy standpoint. But from a research perspective, I think it is quite clear that an opt-out system is preferable in general.
Okay, thank you, Daniel. Yes, so we have a question from Tina Garani Papadatos. Sorry if I pronounced that incorrectly. Tina asks, how long will it take for these provisions of the regulation to be really implemented in the research field? Daniel, your view on that?
Yeah, so I assume you're talking about the European health data space.
I'm
So when it
assuming,
comes,
yes.
yeah. So when it comes to the secondary use under the European health data space, basically in May of 2029, it is supposed to be in full force. So at that point, basically, a potential data user should be able to apply to data sets, and a data holder at that point will have to give access to their data through the health data access body. And that's the current what is currently envisioned, because the EHS is already in force, but there's an implementation period in which basically member states have the ability to fully prepare for the EHDS. So I mean, it is still a question if at that point it will be completely working smoothly. We do not know yet simply. But currently a lot of work is being done. Also, the European Commission will be working on a lot of implementation legislation to give more details on the certain specificities about the use of the EHDS. So yeah, a lot will be happening in the meantime before the EHDS will be in full force. But March 2029 is the date that it should be working.
Thank you, Daniel. I just want to draw people's attention to the chat. Thank you, Everett Ben. Everett Ben has put in a link to a publication entitled Opt-in versus Opt-out for the secondary use of routinely recorded health data. So if you go into the chat, you'll be able to capture that. There's a link to the DOI of the publication. Thanks for that, Everett Ben. We have one further question from Esther Tuboli. Asking about, so Daniel, can you share some information with us if the UK has a similar initiative to EHDS already in effect? And in your opinion, will it be possible to harmonise UK data sets with data in the EHDS? So yes, so the fact is that the UK is no longer part of the EU, so in that sense will not be part of EHDS.
Yeah, so
Daniel, over to you.
from my understanding, when it comes to the EHDS, it does include a mechanism for countries outside of the EU to also take part in the EHDS. But it does work on a let's say on the basis of reciprocity. So it will mean that parties in the UK will also should be able to give access to electronic health data for them to be able to join and also make use of the data sets in Europe. But I don't know the exact full details of how it will work if a country outside the EU would want to take part in the EHDS. But there is definitely the possibility of that happening, yeah. But I guess it also depends on the choices that the UK government will make on this.